Welcome to another episode of Kidon, War Stories from the Cutting Edge of IP, Monetization. My name is David L. Cohen, and I'm the owner of Kidon IP, a consultancy, and David L. Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview other subject matter experts and leaders in the wide world of prosecuting, asserting, analyzing, monetizing, defending intellectual property rights, and various other legal areas around that. You can find this show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and many more. Today, my guest is Dragos Vilau. I know Dragos for many years, and we met in my adventures at Vringo and fights with ZTE, and we have some good war stories to share. But Dragos is I guess, maybe a lion of the IP bar, if you can say such a thing, in Romania. He was admitted to the bar in October '96. He started practicing law in Bucharest, and in one of his first cases dealt with pharmaceutical cross-border litigation while working at the largest law firm in Romania. And as you may recall, and Dragos might get into that, around in the mid-'90s, that's when Romania was basically developing into, without being a little condescending, a modern European nation. And Dragos had a bit of a hand in helping that happen. Dragos developed a significant experience in and expertise in IP and licensing and patent litigation over the past 25 years, and a lot of interesting techniques that we've utilized together. We could talk about that as well. And developed very creative strategies to defend patent rights while maximizing business value for EU and US and other international clients. Various instances where his advisory experience combined with unique litigation strategy and played an important part, as he did with Vringo, in a multinational litigation. Since 2012, he's ventured into the entrepreneurial world of technology startups, of which Romania has a silent but a very powerful role that's often unnoticed. And he's been advising clients and assembling multidisciplinary teams of experts for highly adaptive, multi-industry and specific industry-related solutions, digitization and artificial intelligence. He's currently a senior partner at Vilau Associates, a law firm in Bucharest, and he heads a skilled team there. And he has a recipient of various international awards and recognition. And as I told him, he could be a partner at any major international law firm, but he happens to be in Romania. And so, pleasure to welcome you, Dragos. It's great to see you again.
Hi, David. Great to see you as well. Thank you for the invitation.
My pleasure. My pleasure. So there's a lot to discuss here. So, and probably our viewers don't know too much about Romania. I'm sure they can insert a bunch of jokes about it, but they don't really know what's going on the ground. So maybe we can start a little bit about tell us how you got interested in intellectual property.
Okay. A lot of things going on in Romania, but history-wise, your presentation was spot on. The 90s represents the modern history for Romania, at least in terms of intellectual property. My personal interest started from the university, and that's a bit of irony because at that time, between 1991 and 95, you were not studying that much about IP in Romania, but I was attending some English courses within the faculty, and that's how I got interested. And immediately after the university, I started doing IP. And when I say the 90s represented the modern history for IP in Romania, it's because while we had the patent law in 91, the first, let's say, post 1989 trademark law got passed in 1998. So there was a wide period of time where we had to simply come up with modern practice through a trademark act from 1967.
So just to interrupt you, Dragos, sorry, apologies, but for our younger viewers out there, they may not remember, Romania was under a pretty brutal dictatorship of, I don't remember his first name, but Ceaușescu was his last name. I think it was Nicholas or something like that. And he fell in 91?
89.
89. And I imagine there was a lot of struggles just to figure out how to run the country, let alone secondary and tertiary interests such as intellectual property. So I think you're underselling. You is sort of basically building the law as you're going, you and your colleagues in those days.
Retrospectively, that's how it looks like. At that time, it was just moving from one case to another, trying to find the solutions. Coming from Romania, trying to understand client needs, because that was very important, i.e., we started from the point where every attorney should win the lawsuit whatsoever, to the point of understanding the needs of the client and designing the strategy so as to lead either to a successful case, to a successful win, or to a successful settlement. And that was very important.
And so maybe, you know, and I think that people don't always appreciate that, but sort of how challenging it is to create a system that's fair for everyone, that works and develops client needs sort of as you go. Are there any sort of I would imagine, but I'm projecting that it really helped you sort of think of creative and interesting solutions. But are there any experiences from those early heady days of creating IP in Romania, an IP system in Romania, a modern IP system that sort of impacts how you handle clients today?
Plenty of stories. Nowadays, that may sound funny. At that time, I remember they were each and every a struggle. The fact that I was rather young at that time maybe helped with all the passion. But the experience at that point in time was almost zero. Obviously, you'd start looking for legal writings, you'd start looking for decisions, and there were few or none. So what you would do, you would take each and every case like it's the brand new case in Romania, and you try to deal with it. One story that comes to mind was where we were supposed to cancel a registered IP right. It was a trademark. And we were representing a client that was having a well-known trademark, but not registered in Romania. So this was around 96, 97. You had the concept of the well-known trademarks in the TRIPS agreement, but you'd not have them in Romanian law. So we managed to gather information, go figure, from the customs, with the tourism available, the number of tourists available in Romania that were coming in and out of the European Union, because at that time we were not part of the European Union.
Right.
And with additional evidence that we managed to gather, I believe we got the first decision in Romania acknowledging a well-known trademark without being registered in Romania. At that time, it was rather technical and pretty scary. Nowadays, it's a case law that is being cited in legal writings, and it's a nice story to remember.
Yeah, no, for sure. It shows a creativity in trying to come up with practical solutions.
You had to be creative, otherwise you would just have a bland case. And more to say, the judges in Romania became experienced in IP over the time. So unless you'd come up with some creative strategy and rather solid arguments, mixed with rather solid arguments, you would not win the case.
Right. And so,
go ahead.
No, I mean, if you have any other stories, I'd love to hear them. But I'm curious if so how has the law evolved today? What's it like now to litigate or to pursue IP rights in Romania as compared to, say, most other European countries that our viewers might be familiar with?
It's more or less the same. We have a civil law-based system, so it's more related to Germany and France, with a bit of advantages, I would say, for the time being, in comparison, for example, with the German legal system and the German courts with respect to patents. Romanian courts, Romanian judges, while being quite experienced and having followed various IP courses, they are still pro title holder oriented, pro patent owner oriented. So it's easier to make your case in front of a Romanian judge than by comparison to a German judge.
Right, he was more skeptical.
It's more skeptical about the counter arguments against the patent owner. You still have the dogma in Romania that once you have a registered right, that's it, and it's a valid registered right unless somebody else is challenging it.
Right.
So it's easier to get to the cases. And if you want to talk about something which is dear to me and to you as well, in terms of standard essential patents, believe it or not, in Romania nowadays it's still easy to get an injunction. And in some cases, it's true, but in some cases you can even get it ex parte, which I believe is something that became, I would say, rather taboo in Western Europe.
Yes, I think also we together managed to get the first decision under the new Huawei ZTE regime in Romania. It was on an injunction, upholding an injunction under the regime.
I believe that was the first injunction that got upheld in relation to 4G.
Yeah, that was where the famous 029 patent we had on Cosmos, if I recall. Yeah.
And the funny part is that my IP practice started in a law firm where I created the IP department. With your case, I end up seeing them in court on the other side.
How big is the bar in Romania?
I'm sorry?
How big is the bar of associates and of attorneys? How many attorneys are there in the IP?
I believe we're more than 20,000.
Attorneys or IP attorneys?
IP attorneys, I believe, between 6,000 to 8,000.
Oh wow! Okay.
Quite big. At least practicing IP, both patents and trademarks. And the funny part is that after we got the injunction, they tried 11 times to get it rid, and they failed.
Right. That is another interesting aspect, though, that people do need to understand is the ability to sort of collaterally attack through various other proceedings, a court ruling.
True. It's rather predictable. You can get a main case decision within less than 2 years. The injunction, you either get it or do not get it within 3 months or so.
Mm-hmm.
You would know pretty straightforward the route you're going to take within your strategy. Right.
Are there any other interesting things or developments in Romanian IP law that are interesting just on their own intellectual level or particular interest to our viewers in the English-speaking world?
Quite a lot, because 5G is knocking on the door.
Right.
For various reasons not linked to the law itself or to IP reasons, Romania failed to launch the tender for the 5G licenses.
Oh, interesting.
But still, we started to implement the infrastructure for the 5G. So I expect litigation to pick up, or at least negotiation followed by litigation to pick up not later than next year.
Right.
There is a considerable development in terms of trade secrets and confidential information.
Oh, interesting.
Because we implemented the EU directive on trade secrets. And unless I'm mistaken, I believe we had the very first case where we invoked on behalf of a client the trade secret protection in court, because believe it or not, there seemed to be a practice in Romania to sue your competitor in order to get confidential information via the court.
Interesting. Yes, that's not uncommon strategy in amongst certain unscrupulous clients. I remember that. Actually, one of my first cases was something like that. Yeah.
Yeah. So believe it or not, in some cases they were even successful in getting the information. Obviously, there were remedies, but the point of not disclosing confidential information was lost. So nowadays,
one of the sort of the challenging arguments in that, because I follow trade secrets as well, you may know, in the trade secret in the trade secret litigation space that speaks very much to what you're talking about, is how much does the plaintiff in a trade secret case have to identify what their trade secret is before they get evidence from the third part, from the defendant, whether or not they stole the trade secret?
The system in Romania helps a bit. The court procedural system in Romania helps a bit, because you don't have the discovery part of the litigation, which is pre-trial.
Right.
You go directly to trial. You draft your claim, which could be rather extensive or could be limited. And then you go into the discovery, and then you appoint an expert. And you might get a chance to get the desired information that you try to obtain as a plaintiff before you fully disclose your trade secret. And in some cases, you don't even disclose it fully.
Oh, wow. Because that's sort of interesting, because what's happened in places like California is they've sort of divided a trade secret litigation into two parts, where the first half of the litigation, the plaintiff effectively has to prove that they had a trade secret that was protectable before they get discovery of the defendant to see whether the defendant in fact stole it.
Yeah, we have a rather different system here, which helps the plaintiffs.
Right. The plaintiff whose claim that the trade secret was stolen. Right.
Yep.
Right. That's probably why there's a lot of unscrupulous plaintiffs trying to steal trade secrets in litigation, I imagine.
Not necessarily trying to steal, but trying to get an idea and use that, get an idea about what is going on with the other competitor, and then try to use it in business. Right.
Well, it's always competitive knowledge, and which goes to the point that litigation is 90% of the time a sort of business by other means.
Yeah. True.
Yeah.
True. We're moving from this is over, let's say, a period of 20 years, but I believe we're significantly moving from a 100% litigation strategy to settlements, which is a big plus, because in the past, even Romanian judges were not accustomed to the idea of the parties settling in IP.
Right. That's interesting. Right, because I imagine does that come from their initial training, sort of under Ceaușescu, that someone is right and someone is wrong, as opposed to, say, in civil litigation where you might be both right and both wrong?
Could be, or even they got the training in the early 90s. Let's say that the trainers were not focusing on the settlement part because they were training judges. So
right.
Obviously you're training them how to decide upon a case.
Right, I suppose. Right. Yes, in the U.S., I think a lot of judges become very focused on settling cases once their docket becomes so busy that they don't have time to go for golf or whatever, and or whatever they do in their spare time. I mean, I'm being cynical, but they become very busy and they're trying to manage their docket, and then they start to see, oh well, it's good to get correct decisions, but sometimes it's better for everybody to settle. Is you sort of seeing that evolution as well?
Yes, and I also heard judges, let's say in the past 5 years, at the very first hearing, after looking at the case, asking the parties whether there is any chance of a settlement or whether they are having settlement discussions, which is a progress.
Interesting. Well, so speaking of litigation, that could be another reason why parties always fight to win. I know that in the U.S. litigation is very expensive. In Germany, it's less expensive. But I'm curious, and in Britain, it's also expensive, somewhere between the U.S. and Germany, as is Holland. Where does Romania, and again, I'm the last person who wants to take away your legitimately earned fees, but where does Romania fall on the cost of litigation spectrum?
I think we're still pretty decent comparing to, let's say, the average cost in Germany.
Right.
But these things are changing. So as the practice evolves and the more difficult it will be to get injunctions, I believe that the rates will also go higher.
Right.
So the current.
Go ahead.
The current advantage it's the predictability of getting to a final decision in a rather short time. The still reasonable fees.
Yes.
But also the fact that you can get, for example, you can get an injunction in Romania and you would be able to enforce it across the EU.
Yes, I'm familiar. I'm familiar with that. But that sort of does raise an interesting point, which is sort of a nice segue to another thing. People generally litigate in countries for one of two reasons. Either because the country itself has a significant impact economically, or the country is part of a larger system of impact. And so, for example, people litigate in Germany because, for all the reasons we all know, and some of the reasons you said for Romania, but it's also a huge economy, one of the largest. People litigate in Holland not just because it's a big economy, but because it's the gateway to Europe, to Rotterdam, and there's a lot of customs litigation. My impression is that Romania is, and then other people litigate in other countries because they have tech centers that that are very cutting edge, and they may not have huge economies, but you can shut down their plants, the development plants or manufacturing facilities. And my sense is that while Romania is not a huge economy, it's getting bigger, but it also has a vital role that's not appreciated in a throughway to Southeastern Europe, and it has a huge and thriving technology center, R&D development and manufacturing center. Maybe you could talk a little bit about that and how that's impacted your practice over the past few years.
Okay. In terms of size, Romania is the second largest in Central and Eastern Europe. In terms of IT infrastructure, I believe it's the first. And in terms of also of the increase of startups, I believe it's the second after Poland. Interestingly enough, most of the clients that started to consider litigation in Romania were not considering Poland as an option to Romania.
Right. Interesting.
Yeah, it is interesting. Maybe because the Polish legal system and the Polish courts are closer to Europe and they are more evolved in terms of, let's say, for example, the FRAND discussion.
Right.
And they're not that much pro-patent oriented, trying to follow the English courts practice. Who knows? But it was the option of Western Europe or Romania.
Interesting. Well, I'll tell you one thing that occurred to me when we were litigating was that Romania has the port, I think, of Constance, right? Is a major port of a shipping way through to various locations in Southeastern Europe. And if you can get an injunction there, you cause a lot of damage beyond Romania.
Yes.
Whereas in Poland, if you get an injunction, there was a time when the Siberian Railroad used to bring stuff to Eastern Europe, but not really anymore. And so it's really an injunction as Poland is just for Poland.
True. They're saying that the port of entry in the north is Rotterdam, while the port of entry in the south is Constanța, which is in Romania.
Exactly. So that's another interesting angle from a litigation. But from a more sort of back to your point about startups, I remember back in my Nokia days, there was a large interest in the areas around, I hope I'm pronouncing it correct, Cluj.
Yes.
And there's a lot of technology centers there and development centers. Is that still the case? And what do most Romanian startups and technology development companies focus on? What areas generally?
Not only that's still the case, but it growed incrementally, exponentially. I believe we could easily talk about 7 or 8 cities in Romania nowadays that have more than one, let's say, IT or startup campuses. I was pretty impressed, especially about one in Oradea, which is not necessarily a city that you'd linked with IT and startups. And we got in business relationship with a player over there that invested, I believe, around $15 million in a campus where, go figure, people are living there, working there. They have football fields, tennis fields. They're practicing yoga. It's like a small city.
Oh, wow.
Yeah, and it's really impressive. You wouldn't expect. And then you have Cluj, you have Bucharest, you have Iași, you have Timișoara, you name it. It's quite a frenzy. I believe in 2018 we got the first Romanian unicorn.
Oh, wow.
Which is UiPath, that got listed in New York in last year, I believe. And at the closing bell of the first trading day, the valuation of that company was close to $40 billion.
Wow.
Yeah, exactly. And they are involved in robot process automation.
Hardcore engineering, awesome.
Yeah, which is helping various companies around. I mean, the sky is the limit. You can apply it to each and every industry. At that moment, I believe the valuation of all the existing Romanian startups increased by 20 to 30%. I believe there is another one in the pipeline, or at least one in the pipeline. Last year, it got a Series B financing of $60 million, 60 million euros, which is even more,
right?
plus $1 million, and the current valuation at that time was $250 million. So I expect that the let's say in about a year time, it will be the second Romanian unicorn, unless there is one coming up earlier.
Why do you think that Romania has been so fertile for this kind of development?
Because of the IT enthusiasts and all the people that got really passionate in the 90s, and they some of them saw the future. Some of them just follow the others.
Right. And
you
also probably get more for your euro in Romania than you do in many other places.
You do. We still have an interesting tax system that is encouraging the IT industry, i.e. if you're practicing, if you're working as an employee in technology, you're not paying certain taxes,
right?
Which is still good and also helps the not only the employee but also the employer.
Right.
The industries are the focus on industries is very broad. Obviously, people are trying to find across the industry solutions. but there are some interesting startups that are developing and currently monetizing on single industry-related projects, or maybe two industry-related projects. One that I have in mind is in the cutting leather technology, believe it or not.
Okay.
And the industries that is the target industries are the leather industry, but also the automotive.
Right. Oh, for the seats.
Yeah, exactly.
Yeah. And I imagine that the concept of nearshoring a lot of work back now with the trade wars and the supply chain issues makes Romania especially attractive to a lot of European companies.
True, that we're considering either not moving the business in Romania or moving the business from Romania to elsewhere. Currently, those plans are put on hold, apparently, and either the business will stay in Romania or we will get more business, let's say, from Western Europe countries.
Exactly. And so do you also represent a lot of startup companies, a lot of these startup companies?
Yes, and we're doing it in a very passionate way, because that's how we see the technology developing, and that's where the juice we see it's currently nowadays, if I may say so.
Yeah, I imagine.
You started from the scratch. It's a bit of work in each and every case in order to not necessarily educate the entrepreneurs, but to describe what the real world is.
Yeah.
And
I'm familiar with that problem.
And what they should expect. But seeing them, let's say, on a weekly or a monthly basis, and seeing how the project is developing, it's very rewarding.
I can imagine. And are you giving them solely IP advice or general legal advice or business advice as well?
Mostly general IP advice. In some cases, some corporate advice and contracts. In terms of business advice, it's just on an experience and friendly basis, obviously, because I'm not a business professional.
Right.
But still, a lot of interest. Nowadays, moving from a product-based technology to a platform technology, or to systems that allowed products to work together, or various technology to work together. Because I believe it was a hurdle in the process where you'd come up with a process or a product and you would not be able to implement it to clients on their existing technology.
Right.
And that
Yeah.
was the end.
So that's what's trendy now. So and are your clients looking for foreign investors? Is that one of the things that
They are looking for financing? They're going through all the process with the seeds, the angel and the B series financing. Let's discuss about some numbers. In 2021, the seeds financing in Romania increased 120%.
wow.
It might be because of the pandemic as well.
Right.
But still, there are so many projects, interesting projects in the pipelines. Artificial intelligence, cyber technology, technology that would help clients in their GDPR policy approaching, because that currently today's GDPR rules not necessarily are delaying things, but it's an extra policy that you need to take care. So I have at least one client coming up with a product and a platform designed to address all these GDPR concern and risks and make everything easier.
Right. Right. That's the new regulations create new technology challenges. So Dragos, how should people get in touch with you?
Obviously by Googling my last name, because that's also our domain name. It's www.vilau.ro.
Okay. Is Vilau a common? Is that Vilau a common Romanian last name?
To the contrary, and that's why it would be easier to contact me.
There you go. Okay.
Or they could simply contact you, I believe, and then you'd tell them your impression.
Happy to. Yeah, we've talked about a couple of deals we've tried to put together, and I hope we get to soon. But listen, Dragos, it's been great. I know it's 7 hours ahead from New York where you are, and
Yep.
You probably have a lot of things to close up your day. But happy to have you back and talk about old times or new times to come. And thank you again for spending the last half hour or so with us and talking about a fascinating topic and your key role in helping make Romania the powerhouse that it seems to be today in IT and elsewhere. So thank you again. It's been a pleasure. Once again, this has been Kidon, War Stories from the Cutting Edge of IP, Monetization. Thank you again so much, everyone, for listening.
Thanks, Dave.